I also found an email that I have right here from Jeffrey Epstein to Ghislaine Maxwell that was unredacted. And it included notes of statements that Donald Trump made about his prior relationship with Jeffrey Epstein. Now, there is no reason for this to be hidden from the American people. There is no privilege, there is no attorney-client privilege, and I see you're checking with your staff, and I can assure you, staff, this is not under attorney-client privilege because it was sent from Jeffrey Epstein to Ghislaine Maxwell. Will you commit to publicly providing the unredacted version of this so that the American people can understand the extent of Donald Trump's lies about his relationship with Jeffrey Epstein?
You're about as good of a lawyer today as you were when you tried to impeach President Trump in 2016. Have you apologized for that in 2019?
So will you unredact this? Will you
were
unredact
lead
this?
counsel on that. Privileged.
I'm asking you, will you unredact this?
Privileged.
Privileged, of course.
This directly contradicts Trump's recent public statements that he cut ties with Epstein very early on, even going so far as to expel Epstein from Mar-a-Lago. So why was it redacted? The Department of Justice cited attorney-client privilege, but there was no lawyer in the email chain. It was not communication between attorney and client. It was not legal advice. It was an email between Epstein and Maxwell. Under federal law, what must be protected is the identity of victims, not quotations of statements made by a politician. Democratic lawmakers have called it a bogus privilege, an invalid claim of privilege, and they are asking, if this is merely a misunderstanding, why not release the full version to put the doubts to rest? But the issue does not stop at a single email. Some survivors from Epstein's trafficking network have said they could not find their own interview records in the materials that were made public. If victim statements are not among the 3 million released documents, then where are they? In the withheld portion or excluded from the scope of the transparency law? That law, the Epstein Transparency Act, was passed with a clear objective: maximum disclosure, protection of victim identities, but no concealment of content related to political or legal accountability. However, the law does not include a private right of action. In other words, if the Department of Justice fails to comply, there is no clear legal pathway to force the issue in court. That creates a paradox, a transparency law without an enforcement mechanism for transparency. Meanwhile, another detail has intensified suspicion. The Department of Justice has been accused of monitoring lawmakers' document access history when they entered the data room. In other words, the executive branch tracking the legislative branch during oversight. That raises separation of powers concerns. Congress has the authority to oversee the executive branch, but if the executive knows exactly what lawmakers are reviewing before they question officials, then where does the balance of power truly lie? The political landscape is not simple either. At first, many Republican Party members opposed full disclosure of the files, but as public pressure grew, along with pressure from some members within the Republican Party itself, positions began to shift. Some lawmakers signed onto petitions to force a vote, and once it became clear the momentum was irreversible, the House of Representatives nearly voted unanimously in favor. But supporting disclosure does not mean the records are actually released in full. At the center of the controversy is the question of the Department of Justice's independence. Critics argue that decisions may not be coming entirely from within DOJ, but are influenced by the White House. If that is true, this is not just about an old criminal case. It is about whether the nation's top law enforcement agency still operates independently. To understand why this document battle has become so heated, we have to go back to 2009. At that time, a federal indictment was reportedly prepared containing dozens of serious charges against Jeffrey Epstein, a prosecution that could have exposed the full web of relationships, finances, and power surrounding him. Yet instead of moving forward in federal court, the case ended with a state-level plea deal on far lesser charges. That agreement became became one of the most controversial prosecutorial decisions in modern American history. Epstein served a short sentence, was allowed to leave jail during the day for work, and many potential co-conspirators were not charged. Victims later said they were not properly notified about the agreement. Internal documents from that period, prosecutorial memoranda, communications between attorneys, strategic analysis, are believed to be among the materials that remain unreleased. If so, they could reveal who made the decisions, who applied pressure, and whether political considerations played a role. This is no longer just about Trump, it is about the entire power structure that surrounded Epstein for years. In recent interviews, some lawmakers have said they believe the unreleased materials may include victim interview summaries, internal investigative reports, and even strategic notes from federal prosecutors. If true, withholding those materials would not only affect political reputations, but also the pursuit of justice for victims. Because transparency in this case is not simply a political demand, it is a moral one. Another controversial point is the Department of Justice's assertion that it alone has full authority to determine which documents are relevant to the Epstein Transparency Act and which are not. But who oversees the overseers? When the agency required to provide transparency is the same agency classifying and redacting its own records, the system of checks becomes fragile. Some lawmakers have proposed amending the law to add a clear enforcement mechanism, allowing Congress or even private individuals to seek a court order compelling disclosure. But any amendment would have to pass through Congress itself, where political polarization remains intense. Congress has oversight authority. The Department of Justice has the duty to enforce the law. The courts are meant to resolve disputes. But if the law lacks an enforcement mechanism, if the executive branch delays, and if the courts are not clearly empowered to intervene, the entire process can fall into a legal gray zone. And that gray zone is where politics enters. In recent years, trust in institutions has declined. This controversy risks deepening that skepticism. For some, the withholding of documents is evidence of a system protecting elites. For others, it is an effort to safeguard privacy and due process from political pressure. Two perspectives, one case file, and millions of pages. If Congress continues applying pressure, if the law is amended to include a clear right of action, and if the courts become involved, we may see a new phase of this battle. One centered not on television debates, but on concrete judicial rulings. But if no further steps are taken, if everything stops at hearings and forceful statements, then those 6 million documents may remain in the shadows for many more years.